Justice Barrett?
Mr. Whitaker, I have a question about this editorial control, because really when it comes to platforms that are the traditional social media platforms like YouTube, Instagram, TikTok, Twitter/X, it all turns on editorial control. It seems to me that one distinction between this and FAIR is that here these companies are speech hosts, right? I mean, the law schools in FAIR were hosting job fairs for this purpose, like online recruiting. They weren't gathering together a whole bunch of people and saying, here, present your ideas, present your posts. I mean, these social media companies are hosting speech. So why isn't that more like a newspaper and Tornillo?
It is different, Your Honor, but I think that's why we've leaned on also on the common carrier analogy, which I think reflects that a speech. You can't just say it's a speech host and go home, because if that were true, Verizon could censor. Excuse me.
Well, put aside common carrier for 1 second and just pretend, just put common carrier to the side. Just tell me why this doesn't look like the same kind of editorial control we see newspapers exercise.
Because the platforms do not review. It is a strange kind of editor, Your Honor, that does not actually look at the material that is going on its compilation. I mean, in Twitter versus Tamina, the platforms told you that they didn't even know that ISIS was on their platform and doing things. And it is a strange kind of editor that does not even know that it's the material that it is editing.
Is it because it's not humanized? I mean, human eyes, not human eyes. Is it because it could be an algorithm that says, we want to have, Justice Kagan was pointing out terms of service, we want to have this kind of site. Or some say that, for example, TikTok might have boosted pro-Palestinian speech and reduced pro-Israel speech. That's a viewpoint, right? And if you have an algorithm do it, is that not speech?
Well, it might be, Your Honor, but again, in Twitter and Gonzalez, the platforms told you that the algorithms were neutral methods of organizing the speech, much like the Dewey Decimal System.
Well, that's not what they're saying here. So let's assume that what they're saying here, that they're organizing it, in ways that reflect preferences, that are expressive of their terms and conditions. In that event, do you think it would be editorial control in a First Amendment sense?
No, and I think it's important to separate the organizing, and I agree with Justice Jackson that it's important to separate the various functions. The organizing function from the hosting function, and this is a point that Professor Volokh has made in his article that we cite. I mean, simply because they are required to host certain speech, that does not actually meaningfully prevent them from organizing that speech. So I think the court has to separate out regulation of the organization from simply preventing them from censoring. And the reason, Your Honor, it is different from a newspaper, I think, is two principal points. First, we've been talking a lot about selection, but second, space constraints. Space constraints are something that this court in FAIR and in Tornillo relied on as one factor that is relevant. And the social media companies don't have any space constraints, which means that a requirement to host an additional piece of content is a relatively less.
Well, let me just interrupt you there. I mean, Justice Sotomayor pointed out that even though there may not be physical space constraints, there are the constraints of attention, right? They have to present information to a consumer in some sort of organized way, and that there's a limited enough amount of information that the consumer can absorb it. And don't all methods of organization reflect some kind of judgment? I mean, could Florida enact a law telling bookstores that they have to put everything out by alphabetical order and that they can't organize or put some things closer to the front of the store that they think, their customers will want to buy?
I think first, let me just take a step back, because one of the problems here is we don't have any information in this record on their algorithms. It's very difficult for us to pick apart what exactly the algorithms are doing. You certainly could imagine, I think, to be candid, an algorithm that could be expressive. As far as we can tell, if the algorithms work, though, in the manner that this court described them in Twitter versus Tamina, they look more like neutral ways to reflect user choice. And I don't think there's expression in that. Now, you can imagine a different kind of algorithm. If it were possible to have an algorithm made a website look like a newspaper, that would be different. But again, I think the question of organization is analytically distinct from the separate question of whether they can be regulated in their hosting and censorship.
Okay, so your argument that it's not expressive entirely depends on the hypothesis that the sorting and feed functions are solely some sort of neutral algorithm that's designed to user preference and that they reflect no kind of policy judgment based on the platform itself?
No, not at all, actually, Your Honor, because I think that preventing them from censoring does not meaningfully preclude them from organizing. If they're required to carry a piece of content, they can organize it however they want, generally. I mean, there are prohibitions on shadow banning and the like, but they can generally organize it however they want. So a prohibition on censorship and deplatforming is not, I think, a meaningful interference with organizing. But again, on algorithms, I would just stress that this is a facial challenge. We don't have any particular information on what exactly the content of their algorithms are. And so I think the only question there is whether there's a possible state of the world under which the algorithms are non-expressive.
Okay, let me just ask you one last question. It's about the facial challenge aspect of this. So Florida's law, so far as I can understand it, is very broad, and we're talking about the classic social media platforms, but it looks to me like it could cover Uber. It looks to me like it could cover just Google search engines, Amazon Web Service, and all of those things would look very different. And, you know, Justice Sotomayor brought up Etsy. It seems to me that there are, now Etsy has a feed recommended for you, right, but it also just has shops for handmade goods that you can get. It looks a lot more like a brick and mortar marketplace or flea market, you know, than, you know, a place for hosting speech. Okay. So if this is a facial challenge and Florida's law indeed is broad enough to cover a lot of this conduct, which is farther away from expression than these standard social media platforms, why didn't you then, in your brief, kind of defend it by pointing out, look, there's all this other stuff that's perfectly fine that Florida covers. We don't want, you know, some person who wants to sell their goods on Etsy to be suppressed because it's, you know, stuff, handmade goods that express a political view, for example.
I think we did defend the application of our law to Etsy, and I think I've defended that from the lectern. But I don't think you need to be with me.
I mean, pointing out. I mean, I can sit here and think of all kinds of applications of this law that really wouldn't hit expression. But I just don't understand you to have been defending the law in that way, as opposed to countering the argument that the platforms are not engaged in expression.
We're making both arguments, Your Honor, to be clear. As I was discussing with Justice Sotomayor, we view Etsy as not having a significant expressive interest in applying its policy, its content moderation policy.
So is that enough to just make this whole thing fail, I guess is my question.
Yes,
if
I
we'd
think it
agreed
is.
with you that Etsy, it's fine for it to apply to, or Uber, it's fine, you know, Amazon Web Services, if we agreed with you of all that, is that enough to just say, well, then this facial challenge can't succeed?
Yes, because that would give the law a plainly legitimate sweep. And that's all the court needs to address here, to reject the facial challenge.
Thank you.